traveling nurses who are
No,
multi-state.
home health agencies are using traveling nurses also.
Right. So if they're contracting with an outside traveling nurse group, then
They would not be covered unless we put language in that they are.
that's right.
Okay.
Yeah, they have to be employed directly by the covered employer. So we'd have to make those contract groups, the nurse staffing agencies, a covered employer.
Okay.
But, sorry.
Lynn?
Thank you. I'm sorry I got here late, but I'm trying to do work for the office. My understanding of the way the hazard pay worked was that if you were a nurse in a nursing home, you were treated differently than a nurse who worked in a hospital. That the $25 per hour limit didn't apply to the nursing home nurses, but it did apply to the hospital the hospital nurses. Most nurses make a whole lot more than $25 an hour. I mean, most RNs. I don't know what LPNs or
Oh, nice.
or they just make a lot of money. Traveling nurses make a lot more. Now, part of that is because, so they really wouldn't be qualified under the way we passed the bill last time. And I don't know if it was the nursing homes only got to have some of their personnel covered or all of their nurses covered. But most people in that field wouldn't be qualified under the $25 cap. And certainly traveling nurses. I mean, those people, of course, they cost more because what you're doing is you're also paying for their lodging and the administrative costs for the service that provides the nurses. So you might be paying them 3 times what you pay your nurses that are actually on your staff, but it's not that you pay them, it's that you pay the agency who then pays them, but they still get paid a premium. So I don't know if any of those, I mean, they're going to be expensive. I mean, I don't know how much money it's going to cost to include them, but that's going to really add to the cost of this. And they don't have to come. They're choosing to come. I mean, lots of people went from different parts of the country to where there were hotspots because they wanted to go there. They don't have to go there. It's not like you're hired by Northwest and that's your job and you have to show up because that's your job. You can choose to come or not to come. So I don't know.
Yeah, the $25 an hour cap, the only exceptions to that are employees of home health agencies and nursing homes.
Yes.
And those were separated out because they had nurses who were just above that line. And so that they had been separated out for that reason. But there was a lot of testimony when this bill went through the first time that most RNs particularly are earning well above the $25 an hour cap.
Yeah.
I can't speak for LPNs who I think earn less, but I don't know if they're where they are in relation to the cap. I just think they earn less than RNs. This is kind of it's a question that came up. I don't know enough about those pay rates, but I wanted the committee to be aware that it was out there because this is a question that had come up in the past, and previously on the record, I'd said we hadn't heard from any of these groups to say that they needed coverage. Now we know at least 4 or 5 of these staffing agencies have reached out. Again, I don't know if they have, only 5% of their employees or 0% or 50% would meet the wage and exposure qualification requirements. And that's kind of the big question there. There's also the question of if you're there are other questions too about if you were hired in the middle of this, but you were collecting unemployment for a period, you wouldn't be eligible either. So there are various issues that could come into play here, and I just don't know enough about the staffing makeup for these groups to answer them. It's something that I wanted to put out there. I mean, as from a functional standpoint, I mean, given that this has to move along, there's also the possibility that if the committee wants to look into this more, you could move the bill as it is today out, and with the caveat that you might just do a small floor amendment addressing this issue. It would be a fairly discrete add, but you're right, you would need a fiscal note. You need to get an idea of what this population is. My guess is it would take Joyce and Chloe over at JFO just a couple of days to get the necessary information together to put together a reasonable projection. So it's not something that we could necessarily answer today.
Right. When we did the home health agencies, nursing homes, I know we're allowing them to go above the cap, but is there a cap to that, or is that wide open for them?
It was left to the determination of the Agency of Human Services. I'm not sure how they've construed that at this point. So I just can't answer that. I think it's you're talking about a fairly discrete population.
Yep.
Of employees there, and they have to meet the exposure requirements. So you won't be capturing, for example, the administrative.
Right. No, but your RNs, RNs do make pretty good dollars. And so I'm just wondering, in the guidance that the agency put out on this, I wonder where they set the limit at for them. Okay, Stephanie?
My question was about the staffing agencies, and if in other legislation we wanted the businesses to be domiciled in Vermont, and I'm wondering if that's a concern with these staffing agencies, even though the people are living in Vermont. They may not always be residents of Vermont, but they're living in Vermont for that period of time. But the business hiring them perhaps is not a Vermont-based company.
There's no requirement in hazard pay that the business be domiciled in Vermont. And part of the reason for this is it's not direct assistance to the business, it's to the employees. And so one of the concerns was, for example, let's take Dartmouth Hitchcock operates facilities on the Vermont side of the Connecticut River. One of the concerns was inadvertently excluding frontline employees there just because they work for Dartmouth Hitchcock and UVM Medical Center.
Now. Okay.
Yeah.
Charlie? Charlie, you're...
Thanks. I was just reading through H965 as we passed it to try to tie together what we did for those home health agencies or the companies they contracted with. And it's this long paragraph. And I don't know if it's worth just trying to do that kind of fix to this as well. I don't know what that looks like. It seems like we have a construct in order to make that possible within what we did last time, but it would just be almost, I mean, we're doing it a little differently for the homeless shelters because it could be almost the same way that we did for the home health, for the nursing home facilities. So I was just looking for that type of information to see what that looks like. So that's one question for Damien. And then, Mr. Chair, I have the question in terms of what we know as to what we've allocated by Agency of Human Services for hazard pay to date. And I don't know if the Senate took testimony on that, but it seems like it's either fully subscribed or will soon be oversubscribed, one of those two.
Well, I think that's why they've added that $2.5 million.
Right. So when this was taken up in the Senate a few weeks ago, my understanding was the agency had received a little more than $30 million in applications. And obviously there's $28 million in the fund. Some of the applications were for either employees or employers who did not qualify. But their expectation was that it was fully subscribed. These three technical changes add employees to that group. And so the $2.5 million is the estimate plus a few $100,000 cushion, because there are still applications trickling in for the original bill. And so the feeling was add a little bit of a cushion, just to make sure that we don't, because it is first come, first serve, to try to make sure that you don't have people who are completely left out. But yeah, the $2.5 million is estimated to cover the janitorial, food service, and then janitorial, food service, and hotel motel staff who would be covered in the language I just read through. Plus, the fourth group is former employees. And this was a drafting error on my part, because the bill was originally a present tense hazard pay program, and now it's a retrospective hazard pay program. I didn't change the tense in some of the language. So individuals who worked for a covered employer between mid-March and mid-May and have either since been laid off or switched jobs could not get the benefit because they were no longer on their former employer's payroll. So the new language here allows employers to identify former employees who might be eligible so that the agency can reach out to them directly and help them apply for the grant, and then pay them the grant directly, assuming they qualify. Again, if they collected UI benefits during the eligible period, they're immediately disqualified. And there may be other things, for example, that could disqualify them if they come back and say, well, I was working in the office, or I only worked 20 hours in direct contact and the rest of the time was telemedicine, something like that. So, but that does create an avenue to get to those. So those four groups are estimated to cost a little more than $2 million, and then that was rounded up to 2.5, just to provide a little cushion because the program was already fully subscribed.
Okay. Lynn?
Yeah, thank you. It looks like we also added for staff employed in childcare programs regulated by DCF. Was that in there originally, or is that also new?
Are you looking at S352 or S353?
352. Should I be looking?
You're looking at you're looking at section 16?
Oh, you're looking at section 3.
We're not dealing with that. We're
Okay.
dealing with the technical corrections piece of it. Once we pass this, it'll get sent to Human Services, and then Human Services will deal with the childcare issue.
Okay.
And then it goes to approach. So we have a little time if we're interested in pursuing this further, to include those people that are contracted but that take care of Vermonters. That we have time to have Damien draft the language and also get a fiscal note, because not as important to us as it is to appropriations, that would be ready for them to make a decision on whether or not to include that.
So we're not doing 352. Is that what you're saying?
Yes, we're doing 352, but just these technical corrections, not the childcare piece. That was an added amendment.
Yeah. Okay.
Amendment that was added.
Okay. Janitorial. It's food service,
Hotel workers.
hotel workers, lodgings, and then former employees. Okay.
Right.
Yep.
And now there's a possibility that we take a look at this other group of people that possibly should be included.
Okay, thank you.
Yeah.
So before we move on, is everyone comfortable with taking a look at this further? We get this out today. We can talk about this more once we see language and once we get get something from JFO on what the estimate is. Everybody good with that?
Yep.
Okay.
Okay.
All right, so yeah, if you could take a look at that, Damien, prepare language, so that we can take a look at that, probably Tuesday. Christy, you have a question?
Yeah, just we're doing clarifications or technical input here on this, and I appreciate that, Mr. Chairman. I got a email recently from a funeral home, and within this bill, there is a section for morgue. Does morgue equal funeral home, or does funeral home equal morgue?
No,
It does not. So you're talking about
It
a
does
facility
not.
like within a hospital where they receive the deceased.
yeah, so the funeral home and crematory establishments would be added by the expansion bill, which is S353. So these are two separate bills. And the reason they've been separated is S352. The aim was to capture employees who were meant to be captured in the original bill that the House and Senate had agreed on. And so just basically closing loopholes that we had inadvertently left open that left people out. S353 would restore the employees who were taken out by the House, which included funeral home and crematory establishment workers, because of concerns about the federal guidance here. So the federal guidance could be read two ways. One way would be to say that hazard pay, across the board hazard pay, is prohibited, and it can only be paid to public health, public safety, healthcare, your sort of frontline medical or first responder, public health employees. The other way is to read it to say that the limitations on hazard pay only apply to public employees and don't apply to private employers. And as long as there's a COVID-related reason, the state can provide grants to private employers or to private individuals. And since we had this discussion, I came down on the first reading because it was more conservative. And I felt that that was the safer track to go on because of the potential for federal clawback of money that's spent for an impermissible purpose. Since then, Pennsylvania and Louisiana have passed bills that disagree with that opinion that I gave to the legislature in June. And so the Senate had passed as a separate bill, so it wouldn't hang up the technical corrections and expansion for the House to consider pursuing there. But both Pennsylvania and Louisiana have done it. Louisiana's program is a little unique in that it's a tax rebate, so it might skirt the issue by providing the money as a tax rebate rather than as a traditional hazard pay program. But Pennsylvania has gone right ahead and done it as a hazard pay program that covers for cashiers and that sort of thing. And in that bill 353, you'd get to the private funeral home and crematory employers, whereas morgue is a public employer there, which is why they were included originally.
Thank you, Damien.
Long explanation, but
Okay, so I think Tuesday we'll get into the nitty gritty of 353. So let's look at the rest of the language on the workers that were no longer employed when this came out, but were working during the time period in the bill.
all right, I'm just emailing JFO now.
Okay.
And so the next change in the bill is, I'm going to reshare my screen here. Whoop, sorry, I forget that my laptop is not a touch screen. So this here is one of those catching sort of technical issues. We'd had different language throughout these sections here. In some places we said members of the public or clients. Some places we said members of the public. And one of the things that we realized was that in a lot of these instances, you're talking about folks who may not be dealing with members of the public, but are dealing with patients or residents or that sort of thing. So that's all this is here, is just cleaning up the language so that we're not inadvertently excluding someone. And then the next here is just to cover the janitorial staff. We realized that the original cleaning language required that the individual be cleaning premises that are that's used by individuals who are known or suspected to have COVID-19. But a lot of janitorial staff, particularly in nursing homes, are cleaning areas that are regularly used by individuals who could be infected, but you don't know. And the whole point of putting themselves at that risk is to prevent a breakout or an outbreak in the nursing home where you have a high risk population. And so these individuals would be included here because they're taking the risk in high traffic areas in order to protect our most vulnerable populations here. The next clarifications here, the ongoing community transmission. This is kind of an interesting section here. Vermont was an area with ongoing community transmission for roughly a month of the 2-month period. But we also had facilities with ongoing community transmission of the virus. And we wanted to make sure we weren't inadvertently excluding people who are working in those facilities from the hazard pay in case they didn't work, because the whole, considering the state as an area of ongoing community transmission, because it was only for a limited period of time, there were just concerns here that about inadvertently excluding folks, although they would probably qualify under the close contact provisions elsewhere. But again, this is, as I like to say, belts and suspenders and another belt or suspenders. We're just really trying to make sure they're covered. The next piece here is changing the eligible employee definition to the past tense. This is the drafting error that I mentioned to you earlier, where I'd left everything in the present tense. And so when these questions came up and I looked at the law with the folks from AHS, I said, you're right, it says present tense, so former employees aren't covered. The other issue for former employees, as this committee will be very aware, is the whole issue of once someone is no longer your employee, they're no longer on your payroll. And to bring them back on payroll would be a burden. So there's a whole separate process created for that, so that employers who want to give credit to their former employees can identify those employees to the agency, then the agency will reach out and deal with the grant directly with that employee. Are there any questions about this?
I guess why does that just apply to former employees? Wouldn't it apply to all employees?
It applies to both current and former. The change allows it to apply to former.
Okay, but
Yeah, so these are the current employees, because the eligible period is mid-March to mid-May.
right.
So in some cases, those employees have stayed on all the way through. In other cases, those employees may have left for a different job after the period ended, or maybe even during the period, but they worked the required number of hours to be eligible. Examples could be someone who was working as a nurse in a healthcare facility, but moved back home so that they could be closer to their parents during the crisis here or something like that.
Yeah, I
Yeah.
understand that. I'm just trying to understand why, if the agency felt that they could pay people that are still working for the same company, why do they feel they can't pay people that used to work for them?
Because
You're talking about present tense and past tense. So even when this passed, it wasn't, it was already in the past. It should have been past tense. So
Yes.
why aren't the other ones ineligible then? You know, the ones that have already been paid?
Yeah, so the ones who have already been paid are folks who were working during the eligible period.
Yeah.
Um,
And so weren't the other ones. And
yeah,
so weren't the ones that weren't working, that aren't working for them presently.
but because of the language I'm going to highlight here, so it said is employed by a covered employer that has applied for a grant. And so the agency interpreted the language literally, which is what we asked them to do. And they said, well,
Okay, so it's a
so they
continuous.
basically said,
Okay, I get it. It's a
yeah,
continuous.
you worked the
employment.
hours during the eligible period, but you have to be currently employed. That's what the legislature told us. And that was my mistake when we
I
were
got it. Okay.
last minute, as I forgot to change the tense.
Yep.
So this would make those employees who have left eligible.
Okay. Zach has a question.
Yeah.
Damien,
Definitely.
is there a mechanism for the employee to the former employee to submit an application? You know, I worry about some employers being preoccupied or not having enough time to really be thinking about these previous employees, or in the case of who knows, maybe an employer fired a previous employee and doesn't like them and doesn't want to submit the paperwork for them. Is there a mechanism for the individual to apply, or does that make sense?
There is not. And part of the concern about that was whether administratively the agency could handle an influx of individual applications rather than, and then having to do the follow-up with employers rather than having employers say, these are the employees who qualified. And all along, that's been kind of the process here is employers apply, and you are always at risk that your employer is going to decide you don't meet the criteria. This happened in Pennsylvania. For those of you who are familiar with the chain, Giant Supermarkets just decided not to participate. So all of their employees, they're the largest supermarket chain in Pennsylvania. All of their employees were left out of the hazard pay program because they just decided not to apply. And that's been a potential risk here all along, but administratively, the administrative costs were diminished significantly by switching over to this sort of employer application here where the employer initially identifies people and then it's processed that way. So, but yes, there are potentially people whose employers will just choose not to apply or choose not to do it for former employees or something like that. So there is a risk.
Okay, thank you.
Yep.
Stephanie?
Follow up on the same topic. So so if an employee was employed during the period, the necessary period, no longer with that organization, they would contact their former employer to make sure that they would be receiving the hazard pay. That'd be the only mechanism for them to get.
Yep, they could contact their former employer to say, could you please submit the notice to the agency. The agency is also required to reach out to any employer that's already applied to say, please let us know if there are any former employees who may also be eligible. You don't have to confirm that they meet all of the eligibility. You just have to confirm that they worked for you in a covered job or an eligible job for the requisite number of hours. And then we'll reach out to them directly and do all of the, the social security number and the other application piece at that point. So it becomes kind of a two-step process where they say, can you let us know if there are any former employees that we should reach out to and give us their contact information? Then the agency reaches out, and if the former employee follows up, they can apply for the grant at that point. So basically the agency says, you may be eligible, here's how to apply, and then they'll review the applications at that point.
Okay, thank you. I was concerned that the former employee would have to submit their own application directly to the agency and create
Yeah,
another
so
bureaucratic.
yeah, they will have to apply. Ultimately, they'll have to submit an application, but the agency is going to reach out to the former employers to say, can you identify these people so we can get in touch with them?
Thanks.
Yep.
Lynn?
Yeah, thank you. You talk about administrative burden.
Mm-hmm.
This creates a huge issue for an employer who someone's moved on, they're no longer an employee. I'm gonna guess this has to come out of your payroll just like it normally would. No? Did they send them?
Oh.
They send the grant to the employer and then the employee
So-
passes it
Yeah.
on to the employee.
So, yeah, I think that's further on in the language.
It is. It's actually the next thing we're going to get to.
Okay, I'll hold. Thanks.
So I will answer that. So one piece that we took out here is the restriction on eligible employees do not include an independent contractor or self-employed individual. And we've changed that so it's the number of hours including work performed as an independent contractor or sole proprietor. So the reason for that was that there was concern that you have individuals who are working two jobs. On one, they're an independent contractor, on the other, they're employed. And this was creating some confusion about whether those individuals, or for example, if they left their job and are now working as an independent contractor, but they'd previously qualified, whether they would be excluded from this program. And so this is just clarifying that we are not providing hazard pay for work performed as an independent contractor, but that if you, but you're not restricted from receiving the grant if you have a second job as an independent contractor. Are there questions on that clarification? Okay, so the next thing gets to what we were just talking about. This first piece is just language that allows an individual who is eligible to receive a grant directly from the program, and these would be your former employees, are going to be paid directly by the agency as if they're receiving, or they'll basically be receiving a grant from the state of Vermont. And so these individuals have the option to elect not to receive the hazard pay. The reason for this has to deal with the benefits cliff. There are certain instances where individuals may want to decline the hazard pay because whatever benefits program they're on may not disregard it. In a lot of instances, this income, because it comes in a single lump sum, is disregarded for purposes of benefits programs. And we've also got language in the original bill that directs the state, to the extent permitted by federal law, to disregard this income for purposes of determining eligibility. But still, this is basically saying you're not required to accept the grant, although it's outside of a real extreme benefits cliff scenario. It's hard to imagine any instance where someone would not want to accept the grant. So
Damien,
Yeah.
this is just for the people that were employed during the period and then became, so
It
we're
puts them on
giving-
the same footing as a current employee who can decline a grant.
but in this case, the employer, the former employer is providing name and address. The agency is following up and asking them to file an application. Why would they have to elect not to receive if they're going to file the application? Isn't it at that point that they're making a determination whether or not to accept it? Because they're not automatically being given the grant.
Yeah, that's a good point. As I'm reading this, it says by providing notice, but the providing notice language dates back to when this grant was automatic and you had to affirmatively turn it down.
Right.
So yeah, I'm trying to think whether you even need to allow them to elect not to receive it.
Yeah, because if they're going to fill out an application, then they're electing to receive it. If they don't want to receive it, they don't fill out the application.
Yeah. Okay. Yeah, you're exactly right. This language can come out. Good catch. So that, I guess, would be the committee amendment for Tuesday? Or I can do that for today too.
Either today or we'll do it when it gets to the floor.
Okay. Yeah, I mean, I can, the language, I'm trying to think how quickly I could turn this around. Because yeah, I just strike out this subdivision and then
I think what we'll do,
the original language.
It's probably likely that we will make the change for the contracted nurses. And I think there's a need to get this out today so it can get to human services and then approach. So I think anything that we need to change, we can make an amendment on the floor after.
Okay. I will get this amendment going though.
Okay.
Okay. So the next piece here, now we're getting to representative, what I was just discussing with Representative Dickinson. And so a covered employer may identify potentially eligible employees who are no longer employed by providing their name, mailing address, and any other information required by the secretary. And then the program shall provide the individuals with notice of their potential eligibility and information regarding how to apply for a grant. And then subdivision J here, or subsection J, basically said says they have to provide them with notice of that they may be eligible to obtain a grant and information regarding how to apply. And the notice and information shall be sent to the address provided by the former employer. Moved, hopefully they've provided a forwarding address, but you'll notice this doesn't require the state to track them down, just to, at a minimum, provide notice to the address provided. The notice sent shall inform them that they may elect to decline the grant and provide them with information regarding how to do so. We could just change that to shall inform the individual that he or she is not required to apply for a grant, or even just delete that altogether, since application.
Was there language prior to this that in the original that talked about notifying the employee that they don't have to accept the grant, but was there language that talked about the benefits cliff or anything?
There wasn't. Well, in the original, there was language that basically said that for purposes of determining eligibility for benefits, to the extent allowable, the state would disregard this grant amount.
Yeah, but I mean, did we provide, was notice needed to be provided to the employee to check whether or not they could lose benefits because they accept the grant?
No, I don't think so.
Okay.
So the problem for that is especially for these former employees, you may not have their social security number and so forth. And then for current employees, the employer may not know that they're receiving benefits.
Right.
So in both cases, it's basically up to the employee to know.
Okay. And you said previously, I think a little while ago, that it's unlikely that they would lose benefits because of this.
Yeah, so for some of the programs, the benefits programs, a single lump sum payment like this isn't going to disqualify you anyway. And then we added in language that says for to the extent permitted by federal law, hazard pay provided to an eligible employee through a grant through the program shall not be considered as earned income, unearned income, or a resource for the purpose of any public benefit program, or make hazard pay recipients ineligible for any public benefit programs, including Vermont Medicaid. And so we're basically saying, to the extent that we can disregard this one-time benefit,
Okay.
federal regulations, we're going to do so.
Okay. And so here you're suggesting we just make a few changes in the wording?
Yeah, I think at this point, you could just inform the individual that he or she is not required to for a grant.
But he or she are not required to file an application for the grant, or
Yeah,
not accept the grant, or I mean, once they file the application, they're basically saying they're accepting it.
right. Because at that point, if you're deemed eligible, you're going to get a check from the state.
Right.
So
I guess you can, what the thought is they just, I don't know how to word it, but they're not required to file an application
yeah,
for the grant. If they want the grant, they file an application. If you don't want it, you don't have to file it.
yep. Yeah, I think we just strike from elect to decline through the end of the sentence and replace that with is not required to file an application for the grant.
Okay.
Yeah, and just kind of make clear that, they can choose whether or not to take this money. I think in most instances people will take it, but there may be circumstances where this would change something for them. They don't want to lose a particular benefit due to the additional income, and this will be 1099 income. So it's going to be on a reported for purposes of taxation on a 1099 miscellaneous. So, and then the grant would come directly from the program. So Representative Dickinson, this kind of goes to your question earlier, because these are former employees, in order to avoid the issue where employers are not identifying former employees because they're afraid of the additional administrative cost of putting them back on payroll, reporting taxes, et cetera, et cetera, et cetera, reestablishing direct deposit, whatever it is. They're just providing contact information. The state pays them the grant check and then sends them a 1099 miscellaneous, and the individuals will have to report it on their taxes and pay any applicable taxes on that amount when they file their taxes next year. And then they have to be provided with notice that it may be subject to income tax, to kind of give them the heads up that they may want to set aside a portion of that money. And then the last piece here is because we'll now be collecting Social Security numbers, any personally identifiable information collected by the program, any entity of state government performing a function, or any entity that the secretary has contracted with, has to be kept confidential. And then it's exempt from the Public Records Act. So that's pretty standard language there that covers our bases. Are there questions on that? Okay, the last piece here, section 2, just requires the program to send notice to covered employers that it may identify potentially eligible employees who were no longer employed by the employer at the time it submitted its initial application, and provide information regarding how to identify the eligible employees to the program. And then shall provide, and for the third time, we're saying the program has to provide those individuals with notice of their potential eligibility. So, and
Charlie?
Oh, go ahead.
Damien, just the difference in wording, not difference in wording, but you're consistently, the covered employer may identify potential eligible employees, and that's also above. So it's not a requirement that they identify eligible employees, correct?
That's correct.
So
there's
to Zach's point
really,
before, what happens if an employer decides not to, and that employee is left out?
there's no recourse for that employee in the way the bill exists at this point. In the same way that if you work in a potentially covered job now and your employer decides not to apply, there's no recourse for you. There's no way for you to get that grant if your employer decided not to apply for it.
It would seem to make sense that if the employer is applying for anybody to receive hazard pay, that they have to identify both those who are currently employed and those who are formerly employed.
Mm-hmm. So that could be a change that the House puts in. The Senate discussed that to some extent. One of the concerns that was raised in the Senate, and this was part of the discussion that ended up with the word "may" being left in. And again, I'm not taking a position on this. This is just some of the discussion that I remember on this. Were concerns about, for example, someone who'd been terminated for cause during the either during the benefits period or afterwards, but was otherwise eligible because they'd been working in the position and so forth, but they were terminated for misconduct. The employers may not want to apply for them. And so that was one of the potential issues that was just raised. And when the Senate considered this and elected to leave it as a may.
That's awfully petty. Sorry, if they're applying, I won't make I understand we've got to get this thing out and all of that. I just want to make a point that, if you have an employee and you're applying for your current employees and you did terminate someone for cause for whatever reason, to further punish the former employees, I think just petty. I'll just leave that at that as an editorial comment. I'm not going to do anything about it, but I just maybe that's how the Senate views employees. I'm just saying.
Well, I think what Damien was talking about was when you let somebody go for cause, that means that they've done something that they shouldn't have done, like steal from you or
Yeah.
it's not just, somebody quit and that's it. There's generally a good cause. So I can see both sides of it.
Yeah, but it-
That's why, Mr. Chair, I'm not doing anything about it. I can see the other side too. I just wanted to make a point.
Yeah.
I'll be quiet now.
in an at-will state, though, you could let somebody go without cause,
Right.
Yeah.
right?
You
So
can let
that's
someone go for good cause, bad cause, or no cause.
no
Yeah.
cause. So just
Hey.
seems like if they want to, if an employer wants to play in the game, then they should be covering all the people who are employed during that hazard period. I mean, if we're really trying to thank the people, which is what this really amounts to, thank the people who put money in their pocket for subjecting themselves or willingly working in a role that exposes them to COVID-19, then those employers should be forced to include both those who are still employed and those who were employed during that period.
Thank you, Representative Kimball.
Well, and I wonder if could there be a discrimination issue with that? That could be filed against the employer for discriminating against a former employee and not providing their name when they did provide it for all their other employees?
It, that's a great question. I think it would be a novel legal issue. Certainly it's conceivable that that could be part of a discrimination suit, an alleged harm that occurred in a discrimination suit. I've filed a complaint about sexual harassment. I was terminated because of that. And then even though I'd worked the required number of hours, you also didn't identify me for hazard pay. So it could be a retaliatory termination and then non-identification. But in that case, the individual, assuming that, and this gets to a much bigger question of sexual harassment's a particularly bad one because it's a very high standard to prove. And it's very difficult to prove in court. But assuming the individual could prove it in court, they have a remedy that way where they can get damages. But yeah, I mean, that requires individuals to be able to file a successful lawsuit for discrimination, which in and of itself, depending on the circumstances, is often extremely challenging and a long drawn out process. So yes, there are instances that I can think of where it would potentially be part of the damages consideration and an example of retaliatory conduct or discriminatory conduct, but
well, I just wonder if it sets up the state, making the state look bad, where individuals that had worked for someone, they declined to enter their name, although they did with all their other employees, and the state doesn't have a remedy for it. I just think it could give the program a bad name too.
Yeah, I think in the instant, particularly with a current employee, yeah, if you've got disparate treatment between someone who's in a protected category and someone who is not, I think there's at least a colorable discrimination claim. So if for example, you filed a claim for all of your employees who practiced a certain religion, but not for the one employee who didn't, there you've got a colorable claim of discrimination on the basis of religion. Same thing if you filed it for all the people who were, born in the United States, but you didn't file it for the people who are born in Canada or something like that. That's a clear disparate treatment argument. It gets a little dicier if you've got an instance where the employer alleges that they fired you for cause, and you're alleging that the cause was basically a made up cause to cover up the fact that you'd raised a complaint about discrimination or an OSHA violation or something like that was occurring in the workplace, and they were doing this as retaliation. And then to further the retaliation, they also didn't include you in the list of people who are qualified.
So if they fired you for cause, it would have to be after the period. Because if they fired you during the period, you wouldn't be eligible. Is that correct?
Not necessarily, because the way it's worded now, so imagine you work 40 hours a week in a potentially eligible position. Within 2 weeks of work, you'd meet the minimum working eligibility requirements, assuming that all of those hours of work are in the risk. And it's an 8-week period or a 9-week period. So you could potentially be fired halfway through the period or even 3 weeks into the period and still have met the minimum to qualify for the $1,200 grant. So yeah, I mean, there are definitely potential instances here where there are former employees who could have been fired for this reason. It's really impossible for me to say how likely it is that we're going to find those individuals. I think another possibility is just that you have an employer who says, I'm going to file for my current employees because they stayed with me, but I'm not going to file for my former employees because they didn't. If employees left for greener pastures or something like that, you also potentially run into that. The other thing you run into is, and this is just in the requirements of the program altogether, if someone quit partway through because they, for a valid UI COVID-related quit reason, they don't qualify for this because they would qualify for the federal pandemic unemployment compensation.
Right.
At that point, though, their employer still identifies them as potentially eligible, but then in the application, they'll probably have to check a box that says, did you accept unemployment benefits during that window?
Right.
So there.
And if you get fired, you're not eligible for unemployment benefits. Okay.
Right. If you've been, if you were fired for gross misconduct and your employer reports it, you're ineligible for unemployment anyway, but you could have collected pandemic unemployment assistance.
Okay.
Although
Zach has a question.
Yeah.
Well, it was, I guess, kind of going back to Charlie's question about the may versus the shall, and I'm not really even if somebody was fired for just cause, it doesn't feel like that should be a reason that they don't actually receive this hazard pay. They still obviously risk they're risking something. So I'm trying to find a good reason why a company wouldn't be required to do this if they had employees that were working. And it feels like an employer would want to do this anyways. But you did mention that grocery store chain in Pennsylvania, Damien. Do you know why they decided they didn't want to apply for this hazard pay?
I don't. I just know that they were named in one of the news reports on the Pennsylvania program, which was rapidly oversubscribed. And so, I mean, to put it in context, this is a $30 million program for Vermont. Pennsylvania put aside $50 million for the entire state of Pennsylvania. So that kind of gives you an idea of theirs was available to a broader cross section of employers. So I don't know if the grocery store chain felt that it was too much of an administrative burden, or that they were unlikely to get a meaningful benefit out of it, or what it was. But they were singled out because they were one of the biggest employers that was eligible. And it was public knowledge at that point that they had chosen not to apply, presumably because their employees had made that public, and you could confirm that with the list of applicants from the state. And so it just stood out to whoever that reporter was. So they said, several large employers have chosen not to apply, including this grocery store chain.
Well, that's really interesting. I think maybe there's an opportunity for a floor amendment for this in the future, if you think so. But it does feel like I don't see a real good reason. I mean, maybe that was the case for Pennsylvania. It doesn't seem like it would apply for us. I think our benefits are probably better, but it might be worth exploring, either turning it into a shall or coming up with some sort of mechanism that allows for the individual to apply. Although I do understand that creates a lot of additional work for the Agency of Human Resources, or Services. So I wonder if there's a less burdensome track to allow for individuals to apply.
Yeah, and that's a good question. You'd have to talk to the agency about kind of the burden.
So we've got 9 minutes to the floor. That means we've got about 7 minutes to move this bill. So I think let's think about this, at least turning the may into a shall for businesses that have applied. So we'll see the language from Damien on Tuesday, and then we'll make a decision of whether or not to make that change also. So that'll be in our floor amendment. At this point, is there anything else we need to know, Damien?
Oh, excuse me, there is not.
Okay. So we have all the information.
Yeah.
Is there any more questions for Damien, or anyone need any more clarifications? Okay, Stephanie, have paperwork ready? Okay, so at this point, I would entertain a motion to report favorably on S352.
I'll make that,
Oh,
I'll second it. Whichever.
Yeah, whatever.
Okay, Representative Sullivan moves, and it's seconded by Representative Watson to
Perfect.
report favorably on S352. Is there any further discussions? If not, the clerk can call the roll.
Representative Bancroft,
Yes.
Representative Bach,
Yes.
Representative Carroll,
Yes.
Representative Dickinson, Representative Jerome, yes. Representative Kimball,
Yes.
Representative Marcotte,
Yes.
Representative Morris,
Yes.
Representative O'Sullivan,
Yes.
Representative Tolino,
Yes.
and Representative Watson.
Yes.
Is
None.
Rep Dickinson not back on? Okay.
Yeah, I just have one question. What do we do? I've been trying to do two things at once here.
We're voting on the bill as it stands right now.
Okay, what does that do with the contracted nurses?
Nothing, because we have that'll be an amendment.
Okay, all right, well, I'll vote yes on the, whatever the changes are.
Okay. Representative Dickinson is a yes. All right.
Thank you.
Okay. So it looks like an 11-0. Who would like to report? I've never heard so much silence in my life. Anyone?
Who wants to do it?
I would nominate Representative Bach, but I don't want to subject him to his first bill. I would volunteer for it, provided that we move forward with that amendment. That'd be great.
We move forward with those amendments? Well, I'm assuming we will. I'm hoping we will anyway, but, okay,
And I would be
All right.
happy to.
okay. So what's the process now, Damien? We gotta get it to the floor so it can go, it can move. So does Charlie let the clerk know?
Yeah, I think you let the clerk know that you voted it out.
Don't have a clean copy yet, right?
No, we don't, but I think at the moment you voted to report favorably on the Senate proposal
Right.
without further proposal of amendment. And then the floor amendment that we're going to look at next Tuesday it won't be a committee report, it'll be an individual amendment. So whatever you vote out as a committee can be sponsored by as many members of the committee as want to sign on to it.
Yeah, but does the clerk need the clean copy now in order for Charlie?
I think that's a great question for the clerk.
Okay, Charlie, why don't you just give the clerk's office a call, tell them we just voted it out, but it is going to have to move to Human Services and then to approps. So just tell them a clean copy is coming. The drafters are backed up, and I'm sure they'll let you know what to do.
Yeah, as soon as we get that out, I'll send an email to you, Mr. Chair, and to Charlie, just to let you know that it's available and that you can provide the clean copy to the clerk's office, which they should have too.
Okay,
So then I'll scan this and get this to the clerk's office as well.
I'm sorry.
I'll get this the record of action to the clerk's office as well.
Okay, yep, great. Okay, super. So we're on the floor in 3 minutes. So thank you, committee. Damien, thank you.
You're welcome.
Good work this afternoon. We'll finish this up Tuesday, and then we'll start working on the 353, which would be probably a little more intense. So thank you again, and have a good weekend, everyone. We'll see you on the floor in a couple minutes.
Thanks, Mike.
that the sun shines down.